Lesson 12, Freedom of Religion, Landmark Supreme Court Cases. What does religious freedom mean? How can it be exercised? Those were the questions that ended Lesson 11. Sooner or later, the exercise of one person's freedom will interfere with another person's freedom. Sometimes, too, the rights of an individual may conflict with the rights of society at large. How can we protect the rights of each individual without infringing upon the rights of others? How can we best resolve the conflicts that are bound to occur in a free society when an individual's rights clash with society's needs for peace and order? The Supreme Court is the final arbiter on these questions. Let us take a look at some general information regarding the Supreme Court that will help us understand these landmark constitutional cases. We will have much more to come later regarding the Supreme Court. The Supreme Court consists of one Chief Justice and 8 Associate Justices. That's a total of 9 justices on the Supreme Court. Supreme Court justices are nominated by the President and confirmed by the Senate. It's a 2-part process, part of our separation of powers and checks and balances. Supreme Court justices serve for life. The main job of the Supreme Court is to determine whether laws and government actions are constitutional. A law must be challenged in a lower court and come to the Supreme Court on appeal before the court can decide its constitutionality. The main power the court has is called judicial review. This is the power to determine whether any law or government action goes against the Constitution. When the court makes a ruling, it writes an opinion to explain the rationale behind the ruling. These rulings serve as precedents for lower courts. While the Supreme Court is not bound by precedent, they are hesitant to overturn precedent. One guiding principle of the court is a Latin phrase, stare decisis, meaning let the decision stand. Types of opinions the court writes. The majority opinion is the official opinion of the court. It explains the reasoning behind the court's decision. The majority opinion serves as the precedent for the lower courts. A concurring opinion is a justice who agrees with the majority, but for different reasons. So the justice writes his or her own opinion why he or she reached that conclusion. A dissenting opinion is the opinion of a justice or justices who oppose the majority decision, and they write their reasons why in dissenting opinions. Now, let's turn our focus to freedom of religion as it relates to the schools. The first case we want to consider is from 1940. It's Minersville School District versus Gobitis. The first name in a Supreme Court case is the party that is bringing the appeal of the case to the Supreme Court. So this is Minersville School District bringing the appeal, bringing the case against, in this case, the Gobitis family. Lillian Gobitis was 12 years old, and her brother William was 10, when they were expelled from a Minersville, Pennsylvania public school for refusing to salute the flag and to recite the Pledge of Allegiance. Both of these children were Jehovah's Witnesses. They believe that saluting the flag is a form of worship that violates the Bible and God's commands. Scriptural passages, "Thou shalt not make unto thee any graven image, thou shalt not bow down thyself to them, nor serve them." The father, the parent, Mr. Gobitis, sued school authorities to allow his children to attend school without saluting the flag and reciting the pledge. They believed that forcing students to participate was against their religious beliefs and was a violation of the First Amendment free exercise clause. They won their case in the lower courts, but school authorities appealed, and the case went before the U.S. Supreme Court. Again, that is why the case is called Minersville School District versus Gobitis. The Supreme Court sided with the school system against the Gobitis family. This was 1940. Remember, World War II had broken out, and it was a very difficult time for the world. Certainly in our country, we had not yet entered the war, but tensions were high. From the majority opinion, this is what the court wrote: "The mere possession of religious convictions, which contradict the relevant concerns of a political society, does not relieve the citizen from the discharge of his political responsibilities. National unity is the basis of national security. The flag is a symbol of our national unity, transcending all internal differences, however large, within the framework of the Constitution." The court recognized that, yes, you have religious freedoms. However, that national unity, your political responsibilities, are basically more important than your religious beliefs. Saluting the flag was more important than your religious faith. This is how the court ruled in 1940. Reaction to the ruling was mixed. Hundreds of school systems now made the flag salute compulsory. Many had a salute to the flag. As you can see, that looks a little bit familiar to another salute that was actually going on in Germany at the time. 2,000 Jehovah's Witnesses had been expelled from school by the end of 1942 for their refusal to salute the flag, because the witnesses were not going to yield on this point. Criminal proceedings were brought against children and their parents for refusing to salute the flag. Violence against witnesses broke out. A Kingdom Hall was burned in Maine. There were assaults against witnesses. There was a kidnapping, tarring and feathering of witnesses in Wyoming, expulsions from their homes in Jackson, Mississippi. Most of the nation's newspapers expressed disapproval of the ruling. One magazine sarcastically praised the Supreme Court for, quote, "heroically saving America from a couple of school children." Another said, "Courts that will not protect even Jehovah's Witnesses will not long protect anybody." Many law journals throughout the country condemned the decision. The Supreme Court realized that they may have made a mistake in their ruling, so they looked for another case regarding pledging allegiance and saluting the flag, and they found such a case in West Virginia, 1943, the West Virginia Board of Education versus Barnett. West Virginia regarded refusal to salute the flag as an act of insubordination. Witnesses refused to salute. They offered a compromise. Give a public pledge of allegiance to God first, then to the U.S., but not to the flag. School authorities rejected the proposal. Students were expelled. A 3-judge state court handed down a decision in favor of witnesses. The West Virginia School Board voted to appeal decision, and it went before the Supreme Court. This time the court ruled in favor of the witnesses from the majority opinion. The sole conflict is between authority and the rights of the individual. The very purpose of a Bill of Rights was to withdraw certain subjects from political controversy. One's rights to life, liberty, property, free speech, free press, freedom of worship and assembly, and other fundamental rights may not be submitted to vote. Again, the First Amendment was written to protect unpopular speech, unpopular press, unpopular freedom of worship. In other words, to protect minority rights. One's fundamental rights are not submitted to vote. You do not lose your rights because you are not in the majority. This is the entire purpose of the Bill of Rights. The majority opinion went on. If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or matters of opinion, or force citizens to confess by word or act their faith therein. West Virginia Board of Education versus Barnett is an example that the Supreme Court is not bound by precedent. Just 3 years later, or previously, was the Gobitis decision. So this decision was just 3 years later, and the Supreme Court totally made a totally different ruling in this case. They overturned the Gobitis decision. The result of this ruling is that public school students today do not have to stand and recite the Pledge of Allegiance or salute the flag. In fact, just last week, a lawyer from the Wake County School Board referenced the Barnett decision as a reason why schools cannot compel their athletes to stand during the national anthem. As you know, we are in the middle of a take a knee controversy during the playing of the national anthem. And look at this from the letter of a lawyer representing the Wake County School Board system. West Virginia State Board of Education versus Barnett. The Supreme Court held that students cannot be forced to salute the American flag and recite the Pledge of Allegiance over their religious or conscientious objections. In reaching this decision, the court reasoned that the legitimate desire to promote national unity did not justify compulsion and coerced conformity. This will end part 1 of Lesson 12. We will continue with landmark religious cases in Lesson 13.